Fantastic. Good evening, everyone. I can see a few people, and we're kind of fashionably a few minutes early, which is good. We'll just wait for anyone else who might be joining later on. But hello, I'm Meg. I'm Megan Smith. So I'm head of law and policy for EveryDoctor, and I will fully introduce myself in a moment. But I hope you've all had a reasonable day. Enjoyed listening to our esteemed health secretary coming up with a plan for the NHS, which is always a good thing. There aren't really any ground rules as such. You can turn cameras on, have them off. Probably a good idea to mute, just because I was in a meeting yesterday where there was an enormous amount of clattering going on in the background, couldn't work out who it was, and there were lots of people in it. That's a good plan. If you've got any questions as we're going through, please just stick your hand up in the either a comment in the chat, a question in the chat, or stick your hand up. I'm really happy to be interrupted, or we can deal with stuff at the end and any questions that you might have. The other thing is, is that if you've got any kind of scenarios or like really sort of thorny issues, things that happen that keep coming up. So I know I'm an anaesthetist, so in sort of surgical and anaesthetic practice, particularly surgical practice, I'd say there are often some sort of consent related issues and some thorny issues that come up again and again and again. So if you've got any sort of tricky things like that, give me a shout, and do give us a question. I'll just give a few more people time to sort of log on.
Hey everybody, I'm just making a cup of tea, but hello everybody.
That's Julia. That's the voice of Julia without the face of Julia in the background. So
very odd. Hello everyone, thank you so much for coming. Meg, I was just going to say, just to start, do you want to tell the guys what you've been up to with members recently, because everyone might not be aware of your role.
Yeah, absolutely. That's a really good idea. So I kind of got involved with EveryDoctor. Initially, I was a sort of a peripheral but fairly vocal person in the Facebook group, and then Julia kind of said, would you like to get a little bit more involved? And I did, and then sort of started out doing, there'd be little issues that would come up, questions from members, and I would kind of think, well, as a lawyer, I can probably help with that actually, or I've got an idea about how we might be able to deal with that and help, and so that kind of slightly informal thing moved into a more formal role, and I moved trusts at the end of 2020, always a really good time in between two COVID waves. And rather than do the sort of 12 and a bit PAs that I was doing at my previous trust, I decided to knock it back to 10 and do all give the extra time and probably a bit more to EveryDoctor, who then employed me as a lawyer, which was great. So I've done, I think we're up to about 88, 90 cases for members now. It's a really broad range of issues. I'd say it's probably about 70%, 75% employment law related, usually to do with issues arising with the trust about contractual things, often about study leave, getting bank holidays, proper pay. But I've also done some stuff on pensions for one member, which is quite sort of long and complex, but eventually managed to get him his proper sort of early ill health pension. Some regulatory stuff, so writing to the GMC, getting involved with them, getting a bit involved with the BMA, and quite involved with a lot of the medical defence unions as well. So, but yeah, really, and a few members who've had issues with the police too, which has been kind of interesting, and it's been good to be able to sort of help them as well. But I'd say a lot of it relates to employment stuff, and a lot of it relates to kind of bullying in the workplace and some quite sort of toxic cultures and toxic behaviours. And it's very noticeable when you've got a really, really good culture, and when there's a really quite awful one. And so I've tried to help, or I've been helping a lot of members with those sorts of issues too. So the thing to bear in mind and to spread to your sort of friends and colleagues as well is that if you're a member, then you have access to me, to free legal advice. I think one of the differences between what I'm able to do and what some of the BMA advisors can do, and some of them do, they offer some solid and sound advice, but they're not lawyers, and so I think that just necessarily means that I bring a slightly different take to things. So I quite often look at a problem where they may have said, actually, I think you should just sort of back off or just agree to what they say, and I identify much more of a kind of a legal issue. kind of that might be arguable. So yeah, if you've got any issues going on, do drop us a line. We've got a legal inbox, and we've got a secure Proton Mail legal inbox as well. Yeah, drop us a line and we can help you out, or at least we'll do our darndest to help you out. So I think, where are we? 3 minutes. I think I might make a start. I hope it's okay with everybody that we're recording this session so that other people can sort of watch it back, because this time on an evening might be bedtime and bath time for some people, and it may just be trying desperately to hand over to the night SHO time as well. So hopefully other people would be able to access the session, and we'll probably upload them to our YouTube channel and make them available on the website as well. So that's a bit of a long-winded hello. So I'm an anaesthetic consultant in London, so I work full-time for the NHS. I've got a dark history in that I was a barrister before I went into medicine. So I went off and studied law and did bar exams and practice for just under 3 years. And then I tend to think that maybe I had some sort of small cerebrovascular accident and decided to stop and do medicine. And now I'm really lucky in that I get to do both. So I didn't hate law at all. It wasn't quite the right thing for me. And I really love the fact that I can do both. So I do my clinical work at the hospital, and then sort of 2.5 days a week I do all the legal stuff for EveryDoctor. And the other thing that's brilliant about what I do now is that it says on here that I'm head of law, and I know quite a lot about law, but head of policy and the sort of campaigning aspect of things has been a real learning curve for me, and it's been fantastic because I don't really know very much about campaigning. I know more now than I did 2.5 years ago, but that's where Julia's real strengths lie, and her knowledge lies, and George, who's the other director of the organisation, and our fantastic head of campaigns as well, Hannah. So I've been learning loads about those sorts of aspects of things from them. But the purpose of this evening is for me to chat to you about what is a fairly sort of thorny and I think confusing issue for lots and lots of doctors. I think it's universally, or almost universally, true that we're not really either taught much about sort of legal or medico-legal matters at medical school, or certainly not when I was there. And if we are taught a bit, it's not usually sort of hugely well taught. And it's actually a really difficult area. It's really complicated. And so I'm gonna just sort of cover a few things. Hang on a second. I gave a version of this talk. So I'm an anaesthetist, as I said. I do a lot of regional anaesthesia, so lots and lots of nerve blocks and that sort of thing. And so I've given a couple of talks on consent at the Regional Anaesthesia UK conferences over the last couple of years. And one of my colleagues, Amit Power, who's a bit of a guru in these areas, was the president of the society, and he slightly rebranded my talk, which was pretty much consent law and practice, or how to consent our patients. And in a sort of he trailed it on Twitter and turned it into the How Not to Get Sued course. And then one of the US's kind of big regional gurus as well adopted it. So it kind of became known as the How Not to Get Sued talk. So this is kind of a little bit of a How Not to Get Sued talk, but it's also kind of a let's do the right thing by our patients talk as well. So what I'm going to try and do is lead you through the maze of a very, very complex area. Sorry if I stutter slightly, it's just that other people are just joining. So complex area. I'm going to try and help you pick your way through the minefield that can be all matters medico-legal, but in particular consent, and help you hopefully strike the right balance between saying the right thing, doing the right thing, and not quite getting it right. In terms of questions and issues that we might cover, it's a long list, and I'm not going to be able to cover all of them. The things that I think are important for all doctors to just have a basic understanding of are, so why do we need to obtain consent in the first place? What constitutes valid consent from our patients? Who can give it? That's quite often a big one in surgical practice. It's an interesting one. Can consent be withdrawn by a patient? Is there a limit to what one can consent to? And does consent need to take a specific form? And again, in sort of surgical and anaesthetic practice, but also probably with any interventional procedures in your practices as well, does it need to be written? Can it be verbal? Is it valid if it's verbal? That sort of thing. Refusal of treatment, conditional consent. So I consent to A, but if B happens, I don't consent to you doing C. further or additional procedures, usually again a surgical issue, but not exclusively. So, but the surgeons get into the abdomen and they discover that actually what they thought was just an appendicitis is in fact a terrible cecal mass, and that the person needs a hemicolectomy. Can they do that, or can they not do that? Is it ever acceptable to withhold information from our patients? Is a big question. And how are we supposed to know what a patient wants to know? As I said, I can't really cover all of those topics in this session. It would take us till midnight and you'd all be fast asleep by the time I hopefully got to the end. I'm going to focus on the first two. I'll touch on some of the others as we go through. But if there are any specific kind of issues or scenarios that you found yourselves in, then flag them either in the chat or ask me a question at the end or as we go through. Please do interrupt. For anyone who was in a little bit later, interrupt as we go. I'm very happy to be interrupted and try and answer anything. The other point is that, hopefully I'll sort of cover most of these issues. But as I said, this will be uploaded. We can always do a further session, a more detailed session, or a specific session in a particular area of practice. So PEDS, for example, is a big one, and I've done sessions on paediatric consent for my paediatric anaesthetic colleagues. So we can sort of take it further from there. But these are going to be the basics. So. Sorry, I think every time anyone enters, then I have to use a different way of moving the slides on. So why do we need to obtain consent? Question number one, the $1 million question, really. Well, it's the law. We have to. I say it's the law. This is actually an American case, but it's a restatement of English and Welsh law. It's from 1914, where it was said in the court there that every human being of adult years and sound mind has a right to determine what should be done with his or her own body, and a surgeon who performs an operation without the patient's consent commits an assault. And that's pretty important, I think, to be aware of. In essence, a non-consensual touching of anyone but of a patient is a criminal offence, and that is punishable by a fine and or a custodial sentence. It's also a civil wrong, and that's compensatable in damages to the patient. But if we introduce consent into this sort of little diagram, then what happens is that we convert our non-consensual touching into a consensual touching, and all of the horrible, bad and scary stuff goes away. So what constitutes valid consent then? Well, it's not this, I'm afraid. It's a little bit more complicated than that. And it's a kind of three-pronged issue. So with consent, we have to ensure that the patient has capacity to make a decision about themselves, that they are given the appropriate information to be able to make a decision as well, and that they do so voluntarily. Now, for the purposes of today, I'm going to take capacity and voluntariness out of the equation. So capacity is a whole other session, and that's another one that I think that we will almost certainly do as one of these meetings or webinars, because it's a real thorny issue, again, for pretty much everyone across the hospital, right from A&E through to ITU to, really everywhere. And it's quite complex and thorny again. So I'm going to assume that we're not sort of strapping patients to chairs and inflicting procedures on them. So we'll take voluntariness out of things. And just look at the information that we need to give to a patient in order that they can consent properly. In terms of just looking at those criminal law consequences that I mentioned assault, and that was mentioned in the case. There's assault, battery, which is the sort of the physical action. So assault is making someone fear that they may be physically harmed. Battery is the act of doing it. Then actual bodily harm and grievous bodily harm. And if a patient dies, then obviously there's the question of probably manslaughter as well. Civil law consequences slightly different. There's a civil law wrong of battery, but mainly you'd be looking at negligence claims for so for procedures being carried out without the consent of the patient. You're going to be looking at a clinical negligence claim. There's also the Human Rights Act, Article 8, which is the right to private life, but those claims are pretty few and far between. It's really the bulk of it is negligence. Battery, so this is civil law of battery. The courts have kind of said that it's rarely appropriate to bring a civil law claim against a doctor for battery, and that the only sort of circumstances really in which that should happen is if the doctor's misrepresented themselves, if they've been fraudulent in their dealings with the patient, or if they've acted in bad faith, then that might be appropriate. and the measure of damages is calculated in a different way and can be a lot higher than in negligence. But as I said, the primary cause of action is negligence. And for negligence, or to establish that someone has been negligent, the claimant needs to establish that there is a duty of care owed to them, that duty of care has been breached, and that breach of duty has caused the harm that they have suffered. There are a couple of other more technical points that come after that. If they clear all those three hurdles, I don't think those are ones that you need to really sort of worry about at all. In terms of the duty of care then, so, well, that arises just by dint of the therapeutic relationship. So we hold ourselves out as doctors who are able to deliver medical care, and the patient comes in to the hospital or the GP surgery or whatever other setting it happens to be, and subjects themselves to, to our care, and puts themselves into our care. So we assume a duty of care. Breach of duty of care, so assuming that it's pretty much taken as read that we owe a duty of care, then how is a breach of duty established? How would a patient establish a breach of duty? Put another way, what's the required standard? So how good or bad do we have to be in order to ensure that we discharge our duty of care? Well, this is an old case, 1856 case, which says that in which the court said that negligence is the omission to do something which a reasonable man, it's always a reasonable man, that is not an oxymoron, they do exist, but a reasonable man or woman guided upon those considerations which ordinarily regulate the conduct of human affairs would do, or doing something that a prudent and reasonable man or woman would not do. So this idea is introduced of the reasonable person. So in terms of the breach of duty of care, so who's this reasonable person then? We all know plenty of reasonable and unreasonable people. So who's the index case, as it were, for being a reasonable person? In another nice old case in 1933, the courts in their sort of terribly stuffy way back then said that the reasonable person was the man on the Clapham omnibus. Now the Clapham omnibus doesn't quite exist in that format anymore, so maybe more the man or woman on the 337. It's basically a regular person, your average, ordinary Joe or Joanna, I guess, is the reasonable person. So it's nobody special, nothing fancy, just your average, everyday person. But that's slightly different for professional people, and that includes doctors. So if you're a lawyer, architect, accountant, doctors, anyone with a skill, the standard is different. And this is the case that you've probably all sort of heard about in relation to consent. And negligence more broadly, which is the Bolam case. Lots of doctors know about the Bolam case, and in that the court said that if you're in a situation that involves the use of a special skill or competence, then the test isn't the man on the Clapham omnibus, because that ordinary person doesn't have this special skill. The test is the standard of the ordinary skilled person exercising and professing to have that skill. So it'll be the ordinary skilled doctor. Now that you don't have to possess the highest level of that expert skill in order to be at risk of being found negligent. It's enough if you exercise the skill, the ordinary skill of an ordinary competent person exercising that particular art. So you don't have to be the most brilliantly skilled doctor or cardiologist, anaesthetist or whatever in the world, but you need to be exercising ordinary skill of an ordinarily competent cardiologist, anaesthetist, GP. In a later case in Whitehouse and Jordan, then the court went on to say that if an error is made and it's an error that a person who were acting with ordinary care might have made, then it's not negligent. So it's not this super high standard. Equally, it's not a super low standard either. And again, a doctor is not negligent if they act in accordance with such a practice or with a practice merely because there's a body of opinion that takes a contrary view. So just because some of your colleagues might do differently, that doesn't mean that you're negligent, and vice versa. There's a bit of a balance to be struck. But I've had this discussion recently. I do a lot of vascular anaesthesia, so it's very high risk anaesthesia, and some of the surgeons think that some of the vascular guidelines are wrong and they would like to depart from them. And as a lawyer, I can say that I would not advise that at all. What they need to do if they think that the guidelines are wrong and that they've got better data is that you need to go back to the vascular surgical societies and etc. and get the guidelines changed, because if you're going to be a lone wolf on this, you're going to really struggle to defend a case in court, and it's not necessarily always up to you. So the lead vascular surgeon said, I'm very happy to take the stand and defend my position, and that's absolutely fine, but it will almost certainly never get that far. So most cases are settled, 90-something% of cases are settled long before they get anywhere near a court. So you probably won't have the opportunity to stand up and sort of proclaim how you are correct and the guidelines are wrong. So that's a sort of a slight aside. There are two caveats to this idea that you're not negligent if you act in accordance with the practice just because there's a body of opinion that takes a contrary view, and two caveats to the Bolam standard. Now, the Bolam standard still applies to us for things like doing a procedure. That's the standard. But in relation to consent, it's been added to. So by the Montgomery case, which some of you may have heard about and that I'm going to look at in more detail, there's also a caveat that applies in the case of expert witnesses, and that's an area of work that I do. And there's a case called the Belitho case that sets a slightly different standard there and some other requirements. That's not something that you need to think about at all, but we will look at the Montgomery case. Just a little aside here, the standard in emergencies, because I think this is becoming more and more relevant as we become more and more chronically underfunded and resources are stretched to pretty much breaking point. So in Wiltshire and Essex Area Health Authority back in 1986, the court said that an emergency might overburden the available resources, and if an individual is forced by circumstances to do too many things at once, the fact that he does one of them incorrectly should not likely be taken as negligence. It doesn't mean that it won't be, but should not likely be taken as negligence. So it's almost like an even higher standard if it's an emergency and anyone would be expected to struggle. This, I think, is an interesting point. And again, it comes from quite some time ago, but I think it's even more relevant today. It's almost sort of prescient when it happened. Where an emergency is foreseeable, the hospital authority may be negligent if there's an inadequate system for dealing with the known risks that the emergency is likely to create. And I wonder whether it's not just a matter of time until a patient who comes to harm brings a claim, basically saying whether that would be against a trust, or it may also be against the Department of Health, saying essentially you've under-resourced things so badly that you're not discharging your duty, and so it's an interesting one. I'm surprised it hasn't happened yet, but with the way things are going, I suspect it will happen at some point, and it'll be interesting to see how the courts handle that, because they don't really like to get involved in politics, but that's what this is really. So we've talked a little bit about consent. There's this idea of informed consent, and that's something that's very much valid now. That's what we have to the process that we need to sort of engage in with our patients. Informed consent in 1957 was kind of floated and agreed as a valid and relevant point of law in the States in the Salgo case, where the court said that in discussing the element of risk, a certain amount of discretion must be employed consistent with full disclosure of facts necessary to an informed consent. And it was the first time that kind of idea had arisen. Interestingly, in the same year in Bolam in the UK, the courts absolutely rejected that and said you're not liable in negligence if you've acted in accordance with a practice accepted as proper by a reasonable, responsible body of medical practitioners. So if a group of doctors would have done what you did in relation to consenting your patient, you're fine. Whereas that wasn't the case from 1957 in the States. So you can see there's this kind of paternalistic approach versus the US's slightly more self-determinative approach, and that kind of conflict and that tension has been with us in this country for quite a long time. Bolam definitely came down on the side of paternalism and said it's pretty much up to the medical professionals. In Sidaway, so about 27 or so years after Bolam, the court couldn't have been much clearer and said the concept of informed consent forms no part of English law, and a decision that you take in relation to consent or otherwise is only wrong if no reasonably prudent medical man or woman would have made it. So they pretty much doubled down in Sidaway on the paternalistic, no, it's, doctor knows best side of things. And then there started to be a bit of a shift. And so in 1998, in the Pearson United Bristol Healthcare case, Lord Wolfe said that if there's a significant risk which would affect the judgment of a reasonable patient, then in the normal course, it's the responsibility of the doctor to inform the patient of that significant risk. We'll come back to some of the meanings of the meaning of some of those words in a moment. But then a couple of things happened. So there was the Alder Hey sort of scandal followed by the inquiry. And the same for the Bristol Royal Infirmary as well, where there were lots of issues about samples being taken from babies and children who had died for research and for purposes without the parents' consent. And that kind of rightly was made public, and the families were extremely upset about that. And so those inquiries reported sort of to around the turn of the sort of 2000, and the BRI inquiry said that we needed to have respect and honesty in healthcare, and that might seem kind of bizarre to us now. Lots of people have qualified long after these inquiries, but that kind of very paternalistic doctor in the house approach of Sir Lancelot, you know, was quite prevalent for lots of people. Maybe some who are on this call, but plenty of people who are still practicing. So a need for respect and honesty in healthcare. And that the professional-patient relationship needed to be viewed more as a partnership, and the consent a process rather than a kind of a one-off event. I don't know if there are any other anaesthetists or if there are any surgeons on this call, but I think also for anyone working in the current sort of, or in the modern NHS, in the current circumstances where things are just crazy busy, I'm not sure how much of my consent obtaining process is a process rather than a one-off event. Most of the patients come into day surgery, I see them first thing in the morning, I maybe get 7 or 8 minutes with each of them. I'm then relying on things like leaflets that they've received preoperatively, whether they've read them. There's just not a lot of time, and that's a big issue. It didn't used to be like that when I started anaesthetics. The patients would all come in the night before, you go see them on the ward, you see them the next morning, they'd have time to, you know, mull it over and think about things and ask questions. That doesn't happen now, or for most cases it doesn't. And then in 2004, there was a shift, and I think, you know, a lot of it was triggered by the BRI inquiry and the Alder Hey inquiry, where Lord Steyn said that in modern law, medical paternalism no longer rules. Oops, sorry, how have I done that? Yeah, medical paternalism no longer rules, and a patient has a prima facie right to be informed by a surgeon of a small but well-established risk of serious injury as a result of surgery. So paternalism no longer rules. You've got a right to be informed of a small but well-established risk of serious injury. The question of how small is small or how big is another one that we'll talk about as we work through particularly through the Montgomery case. So that was 2004, and so that case established this obligation to inform, but it didn't really impose on us any responsibility to ensure that the patient understood what we'd given, the information that we'd given them. So it was a kind of, it answered some of, or it addressed some of the issues and some of the problems, but definitely not all of them. So it was still this kind of like paternalism light almost. And then in 2008, the GMC brought out this document, which has since been updated, which started to look much more at this sort of shared decision-making process, which is very much part of what we do now. And certainly in anaesthesia, surgery, any sort of procedures, any sort of high risk procedures that you know, we try to have that kind of shared decision-making discussion with the team and with the patients. Excuse me. And then came about 7 years later the case of Nadine Montgomery and her son, and she had gestational diabetes. So her son was a big baby. She wasn't offered a cesarean section, but she also wasn't. So she was kind of moved towards having a vaginal delivery. But she wasn't told that there was a 9% risk of shoulder dystocia with a vaginal delivery, that there was a 0.2% risk of brachial plexus injury, and a 0.1% risk of compression of the umbilical cord causing hypoxic brain injury. And sadly for her and for her son, all of those things happened during the course of the vaginal delivery. Excuse me. And in this case, it went all the way up to the Supreme Court. And Baroness Hale, who's now left, sadly, but it was pretty amazing, and she did the prorogation case in the Supreme Court. But she said it can now be stated with a reasonable degree of confidence that the need for informed consent is firmly part of English law. So that's pretty unequivocal. So they kind of moved on from those cases, those sort of intermediate cases, and pretty much sort of, you know, sort of stamped some authority on it. So what do we mean by informed consent then? Well, Lord Kerr and Lord Reed said in this case that that we have a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. And I will stress that reasonable alternative or variant treatments includes no treatment at all. And that must be discussed with the patient. I do quite a lot of expert witness work, and I've got a case that's going to trial partway through 2023, which relates to a patient who had a fall when he was on holiday, got a fracture dislocation of his shoulder, came back to the UK, was not offered conservative treatment. It would almost certainly have failed, but was not offered it. He'd had multiple joint replacements and always had a really dreadful result from all of them. So his case is that he would have opted, at least in the initial few weeks, to go with conservative treatment. It wasn't offered to him, so he had surgery, and unfortunately he got a nerve injury from the surgery, and he also got a nerve injury from the regional nerve block that he was given. He was given an interscalene block for his shoulder surgery. And he's very clear that if he'd been offered conservative treatment, i.e. no surgical intervention, that he would have opted for that in the first place. So you've got to cover that as well. It's up to the patient to say, no, I don't want anything. It's not up to us to decide whether they should or shouldn't have anything. So what's material then? That's what the Lords referred to in this case. So what's material? Well, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. And so I'm going to stress the particular case, the particular patient, the person in the patient's position, and that we should know or should be reasonably aware about what's important and what's significant to the patient. That again, in the modern NHS, means that we need to have time to get to know our patient a little bit, to find out what they do, what's important to them, what their life is like. But we can't just have a sort of generic approach anymore to consent. We have to consider the particular circumstances. And so another example, I do a lot of pre-op assessment clinic work, and I was asked to speak to a fit sort of guy who was coming for a hip replacement, and really wanted to avoid a general anaesthetic. He wanted to avoid being intubated, and the reason that he wanted to avoid being intubated is that he sings at the Royal Opera House, so he's an opera singer, and he didn't want to run any risk to damage to his vocal cords and damage to his voice. If you don't have time to get to know that person, then and you just happen to intubate him and do damage to his vocal cords, you'd be in a really, really difficult position. So you need to know a little bit about the patient, but again, the practicalities mean that that's quite difficult for us. And how much do we need to know? How much do we need to ask? So I think what Montgomery has sort of said and shown us is that materiality is context dependent. So it's that situation, that scenario, that patient, not what we think would be important or what would be important to us. What about percentages? I think I've always felt that a percentage rule was sort of rendered us hostage to fortune, and I think that even more post Montgomery. Just because something is a very small risk, if it's important to that person, so the risk of vocal cord damage from intubation is incredibly small, but it would be really important to an opera singer. If you're doing surgery on an eye and the person has already lost vision in the other eye, that may be different. Their take on it may be different from the take of someone who's got vision in both their eyes. So you need to have some awareness about what's important to that patient. If the risk is 0.001%, but it's super important to that person for kind of reasonable reasons, then percentages aren't going to help you. So it needs to be about the patient. And how long does the patient need to process the information? I mean, I would suggest that for most of what we do, most of the time, they don't have anything like enough time to process the information. And I'm not particularly happy to be bound by patient information leaflets or other information that they're given that I've had no control over, and I haven't had any editorial input into them. I think it's a very, very difficult situation, and I don't know exactly what the courts would say. One would hope that they would at least recognise the fact that we are working under incredible pressures of all sorts, whether that's responsibility or time or whatever. And as I say, I've said sort of practicalities in the modern NHS, how achievable is all of this in the modern NHS, and particularly at the moment when we're all under so much additional pressure. And how much to ask? Well, enough. What's enough? It's hard to know. I think as long as you've asked, as long as you've performed an acceptable clerking, and it doesn't have to be absolutely everything, but as long as you've performed a kind of an outline clerking that's appropriately focused to your patient, and that changes as you get more senior, obviously, doesn't it? Because you become more aware of the things that are particularly important your specialty or to what you particularly do, but certainly when you start out, you don't necessarily know what's important and what's not. So I think as you move through your career, that probably changes. Therapeutic privilege, this is a tricky one. It's obviously a very much kind of rooted in that paternalistic approach, which was doctor knows best and I'll make the decisions for you. And some patients will still say, I just want you to do what you think is best. Very difficult these days. You can't really go along with that. You have to sort of sit them down and gently say, no, I really need to talk to you about it because I can't make this decision for you. So therapeutic privilege, rarely justified. I'd say if you're thinking about withholding information from a patient because you think that's the best thing for them, if you're at that point, you should be speaking to your trust's lawyers about it and getting that absolutely kind of nailed on that that's okay. And that's the right thing to do. And also document everything carefully. That's a theme of all the medical legal teaching that I do, and I'll touch on it again towards the end, but document. So if you're going to do this, write it down. So as I said, the sort of pre-Montgomery situation was very paternalistic, very much doctor knows best. Post-Montgomery, we've moved to this much more kind of joint decision-making process, shared decision-making. The patient has a right to self-determination. They have a right to say, I don't want any treatment, even if it's not we would do, even if it's not we would hope, you know, even if it's what we would hope our parents wouldn't do or our siblings or whoever. It's up to them. If they've got capacity, they are entitled to make their own decision. The GMC updated that 2008 guidance in 2020, and again, it's a long document, but it's worth sort of having a skim through at least the summary just to see what the sort of the situation is. Some of you may well have read it, and hopefully in your places of work, you've got at least some training on the basics of sort of shared decision making, even if you haven't had lots of information about the kind of the nitty gritty of the law. As I said, as I started out with, this sort of turned into the how not to get sued talk when I was presenting at the last couple of RA UK conferences over the last couple of years. So in relation to the how not to get sued bit of the talk, then I've got not just the golden rule, but Dr. Meg's 3 golden rules for you. And this applies to almost any of your practice. So first, say it. You have to tell the patient, you have to explain the procedure to the patient in order to obtain a valid consent. And you can't explain it to the patient if you don't understand it. That's much more relevant if you're more junior. So if you're asked to go and consent a patient for a procedure that you've never seen, that you've never done, that you're not happy about, you cannot obtain valid consent. And it might be difficult, you might make yourself unpopular, but someone needs to come and do it with you. You need to see somebody do it, and then they need to see you do it. That's what I do particularly when I do nerve blocks with trainees, or I get the brand new CT1s in anaesthetics coming in. I can't just say to an anaesthetic CT1, go and see the patient, because I have no idea if they know what they're doing or not. They have no idea if they know what they're doing or not. So really important, say it, but you've got to understand what you're saying. Second thing, make sure the patient understands. It's not like it was in those kind of sort of intermediate cases where we give the information, but there's no obligation on us to ensure that the patient understands the information that we've given them. We have to make sure that the patient understands. That doesn't have to be a complicated, convoluted process. We can just ask them, you know, what do you understand you're going to have done today? Just come back to me about what we've talked about. Just summarize what we've talked about. It doesn't have to take loads of time, but you usually get a fairly good steer as to whether a patient has kind of understood what you've talked about or not. And then finally, write it down. And if I had 3 golden rules, I've got 3 golden rules. If I had 100 golden rules, then golden rule 4 to 100 would be write it down. They would all be the same. The reason for this is there are multiple factors here, but the main reason is that what you write operates as your memory, because you will not remember. These issues do not crop up the next day or the day after that. They will come back and arise in a year's time, in 2 years' time, in 3 years' time, and you will not remember. I can hardly remember who I anaesthetized last week, let alone, 3 months ago, a year ago. And so partly you're going to be reliant on what you wrote in terms of your evidence, if you have to give it. The other question here, or the other issue here, is about evidential weight. And ultimately, if it goes to trial, but also in the run-up to a trial, in trying to establish what sort of settlement is appropriate, if one is appropriate, we need to look at what evidential weight a judge would give to each version of events. And so for example, in the shoulder injury case that I was mentioning, so the doctor who did the the interscalene block, absolutely says, I don't remember the patient and I don't remember doing it, but this is what I've written down. And he wrote down some stuff that was fine, but there's quite a bit of stuff that he hasn't written down. And the patient's version of events is very different. And when faced, as a judge, when faced with evidence from a patient who says, no, this is definitely what happens, I've only ever had one nerve block, this is what happened and it was awful. And the doctor says, I don't remember the patient and I don't remember what happened, but this is what I've written down. The judge, on the balance of probabilities, is likely to favour the patient's evidence, in my view. However, if you've written everything down, if you say, I don't remember the patient, but this is what I've written down, this is what happened, this is what I did, I acted appropriately, or I consented for a known complication of this procedure, it is what happened, and I've written down exactly what happened. Even though you don't remember it, it would be a bold judge that would say, well, I don't believe you. I don't believe what you wrote down 3 years ago. So it's the sort of thing that will help tip the balance in your favour. But even if you did it, if you haven't written down what you did, if you haven't written down what you consented for, you're going to really, really struggle. It doesn't mean that you didn't do it, fine, but you will not remember. So write it down is my other top tip. And I'm going to stop there. I'm probably either terrified or perhaps sort of beaten you into submission with all this legal stuff. So any questions I'm really happy to take. I don't know if, let me just see if I can, this is probably pushing my skills to their limit, but I'm going to, well, very quickly, so EveryDoctor, you can find us on Twitter at EveryDoctor UK, Facebook at EveryDoctor, and Instagram at EveryDoctor_UK. So do look us up on all of those different platforms. And there's also our website, which is, I'm sure you've all had a look at. We'll put this recording through the website and up onto YouTube. And so hopefully you will be able to watch it again, should you be crazy enough to want to do that. But if you think that it will be useful to any of your colleagues or friends who haven't been able to watch tonight for any reasons, then do please point them in the right direction. So I'm going to stop screen sharing and let me just see if there's anything in the chat. No, I've completely terrified you all. Has anyone got any questions at all?
Thank you, Meg.
Pleasure, Ju. Aha. So I got on. I'm an anaesthetist as well. You mentioned we get 7 minutes or so in a rushed environment in the morning for a pre-op assessment and consent. How can we justify it? I think that's a super question. And the answer is I don't really know. I don't feel massively comfortable with it, and it's getting harder and harder. I think what I do is I take my time within reason. So I want to be sure that patient has understood. And if it's just if it's a standard kind of a fit young bloke for a knee arthroscopy or something, and they've got no particular medical history, then that's fine. You can do that in a few minutes. But if it's somebody who's much more complex, then I want to spend more time, and I don't counsel many patients, but if I think that they're high risk and that they don't understand it, I usually am not willing to do it on the day because I feel like that's rushing them too much. We've got a pretty decent pre-op assessment sort of setup and situation for patients at my trust, but it's not foolproof, certainly, and I think it's a really tricky one. Yeah, I think you have to be prepared to cancel and just and accept that people might get grumpy with you, but it needs to be done. Thanks for the comments. Can I expand briefly on Blythe? Ian, I'd be very happy to chat to you about that another time, actually, because I'm assuming that maybe you do some expert witness work. It's probably not massively useful for some of the other folks here, but I'd be happy to do that with you if we can maybe just set up a quick call or something. And has anyone got any other sort of burning issues or not able to consent? So when a patient's not able to consent for themselves, for example, fractured nerve dementia, consent form 4, where do we stand? So if only a patient can consent for the patient. So if they are unable to consent, so that's a capacity issue as opposed to just a pure consent issue. And I'll do a session on capacity because it's a really, really difficult one. But if they've got dementia, first of all, don't assume that someone who has dementia doesn't have capacity. And also someone can have capacity for some things and not for others. So it's important not to kind of go, they've got dementia, that's it, they get no say. But if they genuinely have not got capacity, then the consent form 4 is essentially us acting in the patient's best interests. So one of the classic ones that I get, the vascular surgeons, I do love them, but from time to time they come back to me with this kind of, I know, well, the family said it was okay to go ahead. You should say, no, that's not how this works. If the patient cannot consent, then we can act in their best interests, or we may need to go to the Court of Protection in order to get some guidance. But the Mental Capacity Act is very clear, and no one else can consent for a patient. It's, you know, so that's how the fractured NOF or type issue arises. Just as, you know, with a patient who's brought in a trauma call, or who's terribly septic, or who's just, you know, under the influence, you know, those people don't then have capacity to consent, and we're entitled to take particular steps. But as I said, I'll do another session. It'll probably be the next one that I do on capacity. So hopefully those two can kind of knit together. Does anyone have any kind of clinical scenarios that have been very difficult for them, or, you know, that some things have cropped up that have kind of had them either scratching their head or tearing their hair out? No. Well, that's good. So, well, it's about, I don't know, what time is it? It's nearly 8:15. So I hope that was helpful for you, and that it was informative to some degree. It is a bit of a minefield. It's complicated. Sometimes trying to get it into your head takes a while, but we're always here. If you have any questions, do drop us an email, legal@everydoctor.org.uk, and we're always happy to try to help. And if this was useful, thank you for Anand for saying it's useful, then please, you know, sort of spread the word to your friends, get them to watch it, and we will be running additional ones. So I think capacity is one that we'll look at. I think also probably whistleblowing, probably something on employment rights and employment related stuff too. And then I actually also think that something on sort of coronial type issues. So, you know, how do you navigate either complaints, litigation, and coroner's courts as well would be useful. And I'm just sort of, those are things that crop up in my kind of medico-legal role at my trust that I end up helping my colleagues with. So hopefully that will be able to help you guys as well. So the recording, Tala, I think it will go up on the website and be available through YouTube. And Julia's popping something there. Yeah, so if you do that, then and obviously join as a member, then you will be able to watch this and any of the others. And the plan, I think, after this session going forward, one of the ideas or one of the reasons that we wanted to do it was that for some people, some doctors, they just want to know what they should do. They don't necessarily want to know any more detail. It's just like, what's the right thing to do in these circumstances? So we want to be able to answer those questions. There'll be a group of you who will think, oh, I'm a little bit more interested in that. So I'd like to know a bit more detail, but I don't necessarily want to go and read all the cases. So we'll kind of offer a sort of a second tier, a second level of detail for you guys. And then for the kind of weirdos like me who are quite happy to go off and read a House of Lords or a Supreme Court case and really look at the sort of the nuance and the nitty gritty, then we'll provide a kind of an extra layer of resources for you for that as well. So if this has been helpful and you think that would be a good thing to do and a good thing to do going forward in relation to other topics, then I'll be delighted to do it. So wonderful. Thank you so much, everybody. Have a good rest of the evening. Hang in there, support EveryDoctor, and we'll get there together. All right. Take care, everyone.